This is an appeal in the matter of Cifci and London Borough of Sutton.
Miss Burton. Good morning, my lady and my lords. I appear on behalf of the appellant in this matter, along with my learned junior, Miss Kelleher, who sits behind me. Miss Kelleher represented Mr. Cifci in the court below. My learned friends, Miss Screech Power and Mr. Bowl, appear on behalf of the local authority, London Borough of Sutton, neither of whom appeared before His Honour Judge Holmes in the court below. This is an appeal against the decision of the said judge, handed down, I should say, on the 2nd of December 2024, in which he dismissed the appellant's appeal against the decision of the respondent local authority on review, dated 18th of April 2024, that he is intentionally homeless, pursuant to Section 191 of the Housing Act 1996, hereinafter referred to as the review decision, which you can find in the call bundle, page 109. Permission to appeal was granted by my Lord Justice Newey on the 9th of February this year. It's a second appeal, and my Lord found that the test was met in both respects, both that the appeal had a real prospect of success and there was an important point of principle regarding the meaning of intentional homelessness. The grounds of appeal, my lady and my lords, are in the call bundle, page 15. There are two grounds. The first ground is that the respondent/judge erred in determining Mr. Cifci's refusal of an offer of accommodation in Brighton Road caused him to cease occupying accommodation for the purposes of Section 191 of the Housing Act 1996. And ground two, the respondent-judge erred in determining that Church Road was accommodation that was available for Mr. Cifci's occupation and reasonable for Mr. Cifci to continue to occupy for the purposes of Section 191 Housing Act 1996. Two observations at the outset about the grounds, if I may. The first is, it's correct to say that ground two refers to the availability of accommodation in the form of Church Road. In fact, there is no point arising from the question of availability. When we come on to look at the statutory definition, you'll see that one aspect of it concerns the availability or otherwise of the accommodation. There is no issue. I'll explain in more detail as to why in due course. The second observation is this. That Mr. Cifci needs only succeed on one of those two grounds in order for the appeal to be allowed. The local authority must succeed on both in order for the appeal to be dismissed. However, at this stage it's important for me to explain that should the court accept our submissions on ground one, then the issues under ground two simply do not arise. And in my submission, there would be no sense in seeking to determine them. Conversely, if the court is against me on ground one, then in the circumstances of this case, it's unlikely that I can succeed on ground two. And I'll explain the reasons for that in greater detail when I get there. The consequence of that, if nothing else, is just as was the case in the court below, we are likely to spend the vast majority of our time today considering ground one. I will deal with ground two, but within the caveats that I've just highlighted. If nothing else, really, just to explain how the appellant sees that issue panning out in either of the two scenarios that I posited, either success on ground one or defeat on ground one. A remedy, I just point out at this stage that, of course, this court has all the powers of the court below. They're set out in section 204, subsection 3 of the Housing Act 1996. They are powers to either confirm, quash or vary the review decision. And in this case, we seek a variation of the review decision to one that records that Mr. Cifci was both homeless in priority need but unintentionally homeless. Essentially, we say that because if we are correct in our submissions on ground one, then there was only one lawful answer that the review officer could return on the critical issue of causation in the context of the loss of accommodation. My lady and my lords, turning to the facts, it's first of all important to point out that this being a second appeal, the focus of the court is of course on the first decision, the review decision, rather than the decision of His Honour Judge Holmes. One reference you have for that is the judgment of Lord Justice Lewis in Godson versus Enfield, a case that I'll be coming back to in due course, paragraph 5, which is in the authorities bundle, page 95. I will, of course, honour that approach and focus principally on the review decision in due course. However, that being said, I'm going to take you to the facts, at least in the first instance, as they're set out by the learned judge, because it's a concise statement of facts I just don't think I can improve upon. it's a useful platform from which to then analyse the grounds of appeal, although I will, of course, take you to some of the principal documents when actually looking at the grounds in due course. And you'll find those facts then in the core bundle, page 62, and they begin on page, I should say paragraph 1. You'll see, in essence, Mr. Cifci is the father of 2 young girls and is married, so it's a family unit we're concerned with in this case. They lived in privately rented accommodation for an extended period before they were evicted by their landlord. Mr. Cifci made a homeless application to the London Borough of Sutton, and that application was ultimately accepted on the premise that he was homeless and prior to leaving not intentionally homeless, and of course eligible for assistance. Bromley then accommodated the family in temporary accommodation from September 2018 onwards. The last temporary accommodation, which is the relevant accommodation for purposes of the analysis in this case, was 22 Church Road in Croydon. 22 Church Road was temporary accommodation provided under section 193 subsection 2 of the Housing Act 1996. Current purpose is just to explain that there are sort of essentially 2 types of lease of accommodation that can be provided pursuant to a housing duty. Either accommodation in fulfilment of that duty, which is described as temporary but can often be provided for many years, or an offer of social housing, which brings the duty to a final end, social housing being essentially permanent housing, rather than being described as temporary housing. On 8th of November 2021, Mr. Cifci was informed by the property management company of Church Road that the landlord was seeking possession of the property. In the notification letter, he was informed that he and his family were obliged to vacate the property on or before the 15th of January 2022, and that Bromley had been notified of this fact. There is no suggestion, indeed there remains no suggestion, that Mr. Cifci or his family were to blame in any way for receiving that notice to vacate. In response to the notice to vacate, the day before the vacation date, Bromley made an alternative offer of accommodation to Mr. Cifci and his family at 357 Brighton Road in Croydon. Mr. Cifci visited that property on the day it was offered, on the 14th, found it to be unsuitable for a number of reasons, principally related to his wife's health. At that point in time, the property was still being renovated. As the learned judge says, it is not known what state the property would have been in when Mr. Cifci and his family moved into the property, had they done so. Just pausing there for a moment, if I may, I should have said at the outset, I'm sorry, Mr. Cifci did hope to be here today, but he's now pretty much the principal carer for his wife, who's become, unfortunately, even more unwell than she was at the time. I'm informed he's going to try and come along this afternoon, if he can, depending on certain arrangements in relation to his wife's care. I'm sorry I didn't make that point at the outset. I should have done on his behalf. Turning back to these facts then, at paragraph 4, Mr. Cifci did not accept the property at Brighton Road, and in response, as we shall see on the 17th of January 2022, Bromley notified Mr. Cifci that it considered its duties to him under the 1996 Act were discharged. Bromley informed Mr. Cifci that ordinarily he would be permitted to stay in accommodation for 28 days from a refusal in order to allow him to make his own arrangements for housing. However, he was told that this was not possible in relation to Church Road, as the landlord had sought the property back when the notice period had expired. He was told by Bromley that he was required to vacate the property in compliance with the landlord's demand for vacant possession. Paragraph 6, Mr. Cifci notified Bromley that he and his family had nowhere to go. In response, Bromley exercised a discretionary power to accommodate the family for the purposes of enabling Mr. Cifci to find alternative accommodation. The family were accommodated at 226A High Street, Sutton, as an interim placement from 19th of January 2022 until the 13th of April 2022. Just pausing there then, we have 3 sets of accommodation in play. We have 22 Church Road, which the accommodation Mr. Cifci was actually occupying, Brighton Road, which the offered property in discharge of the duty, and then 226 High Street, which was the accommodation offered for the discretionary period of 28 days, which Mr. Cifci did indeed ultimately occupy. Mr. Cifci wasn't legally represented at the point in time. He did subsequently seek the assistance from the Citizens Advice Bureau, and they helped him request a review of the suitability of the Brighton Road property. Unfortunately, he was out of time for that request for review, and Bromley did not exercise their discretion to consider that review out of time. true to say then that suitability of bright note has never therefore been considered on review, as the learned judge noted. On the 13th of April 2022, having been required to leave the property on the High Street, Mr. Cifci made a homeless application to the authority where he now resides, London Borough of Sutton. On the 22nd of October 2022, Sutton determined that Mr. Cifci was homeless, eligible for assistance and in priority need. It also determined that he'd made himself homeless intentionally by his refusal to the property on Brighton Road. So that's commonly known as a Section 184 decision. It's the conclusion of inquiries into somebody who approaches a local authority as homeless in order to investigate what, if any, duty is owed to that particular individual. Mr. Cifci sought a review of that decision. That produced a review in April 2023 that upheld the original findings. That was a subject of a first appeal, which was then compromised on the basis that the local authority would then carry out a further review. That review was then promulgated on the 18th of April 2024 and is now the subject of this section.
And while it's not relevant, just to understand the context, where is Mr. Cifci living now? Is he in accommodation provided by Sutton?
Can I just turn my back for 1 moment? Indeed he is, my lord. He's being accommodated by the London Borough of Sutton pending this appeal.
Yes, I see.
Turning to the legal framework, my lady and my lords, as you'll see, this is dealt with in the skeleton argument of the appellant in paragraph 15 onwards. In very brief form, really for the purposes of highlighting the definition of intentional homelessness in section 191 principally. I may just at this stage, for your lady and lordship's benefit, commend the analysis of the provisions generally, should you wish to review it in the case of Alley versus Birmingham, which is in tab 3, paragraphs 14 to 20, authorities bundle, page 36 to 39, or conversely that of Lord Reed in the Hiley case, Waltham Forest, tab 5, paragraphs 4 to 17, authorities bundle, page 65 to 68, and indeed that of my Lord Justice Newey in the Kyle case, tab 7, paragraphs 15 to 24. Which is authorities bundle 113 to 114. So rather than me go through all of those provisions in a summary form at this stage, I'm just highlighting them should you wish to look at them in that sense. As we say in paragraph 15, of course, the critical point really is that the main housing duties as so described is only owed to families who are not only in priority need and homeless but are unintentionally homeless, which is why the question of intentionality is so important in the context of homelessness provisions. And the test is set out in section 191, which is set out in the skeleton, or you can see it in the authorities bundle, page 131. We are in this case only concerned with subsection 1, which is the principal definition. A person becomes homeless intentionally if he deliberately does or fails to do anything in consequence of which he ceases to occupy accommodation which is available for his occupation and which it would have been reasonable for him to continue to occupy. So obviously there are several components to that test, but they're all contained within that one subsection. Paragraphs 18, we say the test in section 191 is a complex one that has been refined over time by the court. I know I'm responsible for this skeleton argument, my name's on it. I'm not sure actually I entirely agree with that description. It's not necessarily complex, but it has generated quite a bit of case law over the years. And it's probably important to point out, as is described by Lady Hale and Lord Reed in the cases I referred to a moment ago, that it's existed since these homelessness provisions were created in the original Act, which was the 1977 Act, essentially in the same form. So the statutory provision has remained the same, but it's certainly correct to say that a number of issues have cropped up in the context of that definition over the years. However, all I believe at this stage we need to focus on is the extract which we set out in paragraph 18 from the judgment of Lord Reed in the High case, set at paragraph 25. I wonder if we could just look at that. Again, of course, my lady, my lords are free to look at that, of course, in the case itself, or indeed in the skeleton argument. If you want the reference for the case, it is.
It's tab 5, I see.
Tab 5 indeed, and page 40 in the authority. No, that's wrong, sorry. Sorry. 59, thank you very much, my lady. Oh, Hiley is there, sorry, yes. I do apologise. I was taking it from the skeleton and hadn't pre-prepared the reference in the case itself.
70.
Page 70, yeah, very good. Now, in the broadest possible terms, what the case of Hiley was concerned with was the interrelationship between a potentially intentional act or an episode of intentional homelessness and the current state of homelessness at the date of the application to the relevant local authority. And the example that Lord Reed used to try and draw all this out was of a man who was rendered homeless by the closure of his care home, having 25 years previously lost accommodation because of antisocial behaviour when as a student. He said, well, obviously it can't possibly be right that the mere fact that local authority can identify a full intentional homelessness 25 years ago would mean that he should be deemed to be intentionally homeless now. That was a hypothetical example, I should point out, wasn't the facts of that case. I explain that really just so you understand the context in which the conclusion section in paragraph 25 is set out. So section 1931 must therefore be understood as being concerned with the question whether the applicant's current homelessness has been caused by intentional conduct on his part, in consequence of which he ceased to occupy accommodation which was available for his occupation and which it would have been reasonable for him to continue to occupy. Either the accommodation which he was occupying immediately before he became homeless or previous accommodation. Whether the applicant became homeless intentionally thus depends in the first place on the application of the definition of becoming homeless intentionally in section 191 that is just set out and we've just looked at. In short, on whether he deliberately did or failed to do anything in consequence of which he ceased to occupy accommodation meeting the requirements of that provision. If that question is answered in the affirmative, the further question then arises under section 1931 whether the applicant's current homelessness was caused by that intentional conduct. So the first part of that test is very much in the question as to whether or not there had been intentional conduct that led to the loss of accommodation that was in fact being occupied and which otherwise met the requirements of the Act. The second part is a more open question as to whether or not the current state of homelessness is attributable to that previous intentional conduct. So there are essentially, when one looks at this section 191 test, two dualities in play. And the first on causation, the one I've just set out. First, there needs to be causation between the intentional conduct and the loss of accommodation. And second, there needs to be causation between that intentional conduct and the loss of that accommodation and the present state of homelessness. The second duality concerns the nature of the accommodation. This only arises, of course, if the accommodation was otherwise lost due to intentional conduct. But was that accommodation available, and was it reasonable to continue to occupy it at the time of the cessation of occupation of that property? Just to point out now, because I'll come back to this in due course when explaining the analysis in relation to ground 2 and reasonable to continue to occupy, that when one considers the question of whether or not a property is reasonable to continue to occupy, one is obliged to ignore the deliberate conduct or deliberate act. And that comes from the decision of Lady Justice Arden in a case called Denton versus Southwark. It's not in fact in your authorities because it's an agreed statement of the law. But fundamentally, my lady, my lords, that explains why we say if you're with the appellant on ground 1, there's no real sense in seeking to then determine ground 2. It's actually very hard to do that if one doesn't have a deliberate act in question that one has to then ignore to analyse the question of reasonable to continue to occupy.
And sorry, the Lady Justice Arden was in what case?
In Denton versus London Borough of Sutton, I can give you the case citation in a moment. Perhaps I can just ask my learned friend to pick that up. It's referred to a number of times in the authorities. We do have, and one good reference for it is it's discussed by Lord Justice Lewison in the December versus Kensington and Chelsea case, paragraph 17, which is in the authorities bundle, page 57.
Yep.
I mean, Denton was a case effectively where the occupier behaved badly and his landlady then fell out with him and as a consequence served notice of him. And then he said, well, it wasn't reasonable for me to continue to occupy that property because I'd fallen out with the landlady. And one can see quite quickly why that wasn't a satisfactory analysis for the purposes of reasonable to continue to occupy, because one could bring about a case of unintentional homelessness by bad conduct. So what Lady Justice Arden, which she then was, said, well, obviously you have to then keep out of account the conduct you've identified as ostensibly being the deliberate cause of the loss of accommodation when analysing the second question, which is whether or not it was reasonable to continue to occupy that property. So in that case, it meant leaving out of account the bad conduct which had led to the breakdown of the relationship with the landlady. And then you ask the question, well, was it reasonable for you to continue to occupy that accommodation on the premise that you didn't behave badly? And the answer is straightforward, yes it was. Is that clear? So that, just to highlight again, is the principal reason why we say if you're with us on ground 1, there's no point going on to analyse ground 2 because there is no deliberate conduct that one can focus on and indeed focus on ignoring for the purposes of the analysis. I'll explain that in a little bit more detail when I actually come to ground 2. My lady and my lords, at paragraph 19 of our skeleton argument, we set out the sequence of questions asked under this section, which is actually comes from Luber and al.'s 6th edition of homelessness law, which is in that oft-cited expression, the Bible, in relation to this particular area of law, and indeed was referred to explicitly by the judge at paragraph 19 of his judgment. And I'm sure my learned friend and I can agree that these are the relevant questions under an intentionality case. And in my submission, they come in the appropriate order. First of all, you look for the deliberate act or omission, and then you ask, was that act or omission by the applicant? And then you ask, as the first limb of the causation question identified by Lord Reed in Hiley, did the applicant cease to occupy accommodation in consequence of that act or omission? And then the second causative element of the Hiley test, was that act or omission the operative cause of the present homelessness? And then you move on to, if you cross all of those tests, the questions that concern the nature of that accommodation itself, whether or not it was available, whether or not it was reasonable for the applicant to have continued to occupy it at the material time. Just for the avoidance of any doubt, it's never been the case, apart from one judgment of one particular lord in one case, which was quite quickly disavowed, that you needed to be able to show it's reasonable for the person to continue to occupy that accommodation all the way through to the period of the application itself for homelessness assistance. I'll again develop that a little bit in due course, but one might have thought at one point that would be a natural interpretation of the provision, but insofar as it was natural, it was also wrong. Not endorsed by course. And therefore, the principal focus really of this appeal, and certainly ground 1, is C, the first causative element. Did the deliberate act identified by the local authority, namely the refusal of Brighton Road actually caused the cessation of occupation of Church Road. We say it plainly didn't. The authority, the respondent says, made a finding that it did. I'll come on to that in a moment. Then the second questions that arise under ground 2 are whether or not it was available and whether or not it was reasonable for the family to continue to occupy it when they ceased to occupy it. So just dealing with the availability question now, availability in this context doesn't necessarily mean one has a tenancy or necessarily hasn't been the subject of a notice to quit or notice to vacate. In the context of residential accommodation, it is always available until such time as there a court order actually evicting you as a question of law, which is why you see precious few cases about the issue of availability. But what we'll see when we come on to it is where the law stands on reasonable to continue to occupy is that if there has been a notice to quit, then the guidance suggests that if there isn't any defence to that putative claim for possession, and there are no steps underway to negotiate a period of, as it were, overstaying, pending, for example, the provision of alternative accommodation, then it would not ordinarily be reasonable for the occupants to continue to occupy. I'm really just saying that by way of background so you have a sense of the shape of how these provisions interrelate. So, my lady and my lords, the council's decisions in this case, if we could begin with the 184 decision made by the London Borough of Bromley, let me start again. This is the London Borough of Sutton's decisions in this case, of course, not the London Borough of Bromley, so the ones we're concerned with. And we're looking first at section 184 decision, which is not the review decision, it's the one that's subsequently reviewed, which is in the core bundle. And it begins
Must be 1, 2, 3.
yes, sorry, my page number's gone. Yes, it begins at page 1, 2, 3. I do apologise. And what we see if one turns to page 128 is a summary of the conclusions reached at the, as it were, first instance. And you'll see there those respective limbs of the intentionality test set out. So under question A, did the applicant deliberately do something or fail to do something? In my consideration, the deliberate act was your refusal of the section 1932 offer of accommodation by Bromley Council. That was the Brighton Road property, of course. Did the applicant cease to occupy their accommodation at 22 Church Road, Croydon, in consequence of their deliberate act? There is no ambiguity in this matter. You clearly ceased to occupy your accommodation as a result of refusing the 1932 offer. And then on D, was it reasonable for the applicant to continue to occupy the property? And all that's really dealt with there is, as it were, the nature of the property from a size and arrangement perspective. There is absolutely no reference to the relevance of the landlord's notice to quit in any of that analysis. But of course, there is then the review decision where those matters are raised on behalf of Mr. Cifci. And so we then see the review decision, which is the subject of the appeal. That begins at core bundle 109. Invite you to turn up 120, which is where we see on the review stage of the analysis the same breakdown of those respective components of the review officer's decision. Now, keeping in mind the review officer has now been made aware in clear terms about the existence of the landlord's notice, etc. Of course, I'm going to take you to those facts in a bit more detail, but you have a broad understanding of how they played out from the learned judge's description of the facts below. So A, did applicant deliberately do something or failed to do something? In my consideration, the deliberate act was ceasing to occupy 22 Church Road. You should have accepted the property at 357 Brighton Road and requested a review of suitability. If you had, you would not have become homeless. Bromley Council had a duty to keep you accommodated until you were in a settled home. And then B, we can skip over for the reason B is, did the applicant cease to occupy the accommodation? You ceased to occupy 22 Church Road, Croydon, and Bromley Council, in consequence, discharged its duty towards you, following your refusal of accommodation at 353 Brighton Road. And then we see C under the question of would a property have been available for the applicant to occupy. And you can read the words used by the reviewing officer thereunder. They're not the clearest. You can see from the first paragraph it said that 22 Church Road was provided to you by Bromley Council in accordance with their section 193 duty. It did not cease to be available as a result of the landlord's notice. You would have continued to enjoy rights of occupation. Possession of this property was not recovered without pursuit of a court order. Now that's consistent with the analysis I already explained about availability. The landlord did not take possession proceedings and evict you in consequence of the notice. Rather, you left in consequence of the duty being discharged following your refusal of accommodation by Bromley Council, and thereafter being provided with discretionary accommodation elsewhere by Bromley Council in accordance with its practice to give reasonable notice. Moving on, 22 Church Road, Croydon remained available and reasonable for your continued occupation. Bromley Council offered Brighton Road in its continued performance of that duty. Their duty to continue to accommodate you under section 193 ceased when you refused the offer and they discharged their 193 duty to accommodate you, and but for that refusal you would not have become homeless. It is clear that if you had not left 22 Church Road, Croydon and accepted accommodation pending a review and the offer of accommodation, you would not be homeless today. 22 Church Road, Croydon did not cease to be available as a result of the landlord's notice. Your loss of accommodation was by no means inevitable. The Bromley Council had an ongoing duty to make you a reasonable offer of accommodation until they no longer had a duty towards you. This meant you had to be housed until you were offered permanent accommodation. And then D, finally, was it reasonable for the applicant to occupy the current accommodation? I concluded that 22 Church Road, Croydon was suitable for you to continue to occupy until the landlord obtained possession with a court order. This accommodation would have been reasonable in the short term. You should have requested accommodation pending a review. The accommodation you had was reasonable and you should have allowed due process of the review process to follow its natural course. If you'd stuck with this, I'm satisfied that Bromley Council would make you a suitable offer alternative to pursue their 193 duty. So, my lady and my lords, moving then to ground one. It's clear what the local authority identify as the deliberate act. And as ground one states, the criticism is that the respondent erred in determining that Mr. Cifci's refusal of an offer of accommodation at Brighton Road caused him to cease occupying accommodation, namely Church Road, and that was available for his occupation. Now, if we look at the question of the deliberate act in A, and then look at the question of causation in B, what we see there in our submission is plainly insufficient to justify the decision. In A, it said, in my consideration, the deliberate act was ceasing to occupy 22 Church Road, Croydon. You should have accepted the property at Brighton Road and requested a review of suitability. If you had, you would not have become homeless. Bromley Council had a duty to keep you accommodated until you were in a settled home. And then under B, you ceased to occupy 22 Church Road, and Bromley Council, in consequence, discharged its duty towards you following your refusal of accommodation at 357 Brighton Road, seemingly suggesting that the discharge of duty followed on from the cessation of occupation at 22 Church Road. So what we say in our submission is that the reviewing officer's answer to the first question is plainly directed towards the appellant's state of homelessness and whether that is attributable attributable to the refusal to accept Brighton Road. Is not directed towards and does not address the prior question, which is whether the cessation of occupation at Church Road was a consequence of the deliberate act, maybe the refusal to take up the offer of alternative accommodation. This impression is not dispelled by...
Sorry, can you, I'm trying to write that down, so can I just have that again?
Yes, so we say the best interpretation of the reasoning under A is that the focus, or at least the finding, is really directed to Lord Reed's second causation element, looking at the present state of homelessness and saying that that is attributable to the failure to take up Brighton Road.
Yeah.
The last paragraph, the last sentence being instructive. If you had taken it up, you would not have become homeless. Bromley Council had a duty to keep you accommodated until you were in a settled home.
Yeah.
And then in our submission, the answer under B, did the applicant cease to occupy accommodation, doesn't help much either. What you don't see is any clear explanation as to why the refusal to accept Brighton Road was in fact causative of the cessation of occupation of Church Road. That's the prior question that had to be answered before you get to the second stage of the analysis.
So your focus is on the first causation test, if I could put it that way.
Yeah. And we say, at least in this part,
because the first causation test is directed at whether you are intentional or have been intentionally homeless, rather than the elderly man in the care home second stage.
Exactly, my lady. Yes.
Okay.
And so what's impermissible is to ignore the first causation test and move straight to the second and identify a deliberate act, the refusal of Brighton Road, and then say, well, that explains your current homelessness. Because if you'd accepted it, you wouldn't be homeless today. You'd be accommodated by London Borough of Bromley, which may in fact be true, but doesn't address the critical prior question, which is whether or not the loss of Church Road was attributable to that refusal to accept the alternative accommodation. But we're compelled, and I don't shy away from this, to give the reviewing officer some leeway in terms of how he expresses himself. And what we do see, and I took you to this earlier, but under a different part of the test, under item C, which was actually addressed to the availability of Church Road, the paragraph that I took you to a moment ago, which says, so we're back at page 120. Bottom, the final paragraph. So, albeit this addressing a different question about availability, there is the following sentence. The landlord did not take possession proceedings and evict you in consequence of the notice. Rather, you left in consequence of the duty being discharged, following your refusal on offer accommodation by Bromley Council, and thereafter being provided with discretionary accommodation elsewhere by Bromley Council, in accordance with its practice to give reasonable notice. So there is an attempt to tie the refusal to accept Brighton Road with the cessation of occupation of Church Road. So I take that on board. And my learned friend will urge you to treat that as a material part of the reviewing officer's reasoning, and I'm of course happy to do so. Now, of course, it's correct. The first sentence is correct, insofar as it's correct that the landlord had not taken possession proceedings by the time Mr. Cifci's family ceased to occupy 22 Church Road. Accept that. But in our submission, it's not correct that Mr. Cifci ceased to occupy Church Road because of the discharge of duty following his refusal of Brighton Road. He ceased to occupy it because of the landlord's notice to vacate. So, my lady and lords, this is when I take you to the documents to make that proposition good. So if we could begin with the notice itself, which we see in the supplementary bundle now, at page 3. I'm sorry that the typeface is a little small on this. So this is coming from Crest Manor Limited, who are the managing agent of the Church Road property. just again for clarification, when one is in accommodation provided pursuant to section 193 in fulfilment but not discharge of the duty, there's no prohibition on the local authority securing that accommodation is made available by a third party, namely a private landlord, which is essentially what happened in this case. I'm writing to inform you that the landlord, 22 Church Road, has notified us of their intention to take back the above property. For this reason, which is beyond our control, we are therefore serving you with this notice to vacate the property on or before the 15th of January 2022. We have notified your council, Bromley Council, to secure the accommodation for you. If you need any help with this notice, please contact Bromley Council Housing Management Team. Note, after this date, any personal belongings left in the property will be removed and disposed in accordance with the company policy, except if we've made an alternative arrangement with you for your council. I'm just pausing there to note that the 15th of January 2022 was a Saturday. So this notice was expiring on that Saturday, and this of course was sent to Mr. Cifci on the 8th of November 2021. If we just scroll down now to supplementary bundle 4, you'll see now an email from the council to Mr. Cifci. I hope you're well. Following on from my earlier email this week, sent an email on the 8th of November, there's nothing material arising from that, regarding the landlord's wish to take back the property from the provider, you now should have also received an official notice letter, as indeed he had. We've just looked at that. Unfortunately, there isn't much that can be done when this happens, so reinforcing the point made by the agent that this was outside of control of the agent and the council. Before the notice period expires, you will be made an alternative offer of accommodation. The team responsible for this will be in touch in due course. So there we see London Borough of Sutton indicating an intention to make an alternative offer before the notice expired. If we then turn down to page 7.
Just while you do, as I look at this, I see page 4 is the 11th of November, page 5 is the 9th of November.
I incorrectly said the 8th of November for that email, sorry, it's the 9th.
But actually, they seem to say much the same thing. Perhaps it doesn't matter.
One, I think I think the first one is written in ignorance of the fact that a notice has either been prepared, sent, or indeed received by Mr. Cifci dated the 8th of November. And then when we see the email of the 11th of November, the writer is now cognizant of the fact that a notice has in fact been served on Mr. Cifci.
That, it really doesn't matter, but I see in the third sentence of the 9th of November, he says, you should have received this information from your provider already. But anyway, so there are 2 emails to similar effect, seemingly.
Yes.
Yeah.
Just out of interest, do we have the first part of the email from your client? Which
We don't, unfortunately, in the bundle, no. Which is sent earlier on and indicating some concerns about where he might be reaccommodated.
Exactly. I couldn't find it.
I mean, that material is, of course, part of the background. It's very important to my client. Not going to
But not really relevant to.
But not ultimately relevant to legal issues before you. He missed his chance to seek that review, and that's an unfortunate side issue.
Yeah.
I mean, what you can see that, which is perhaps of some relevance in the 9th of November email, is a sequence of events that appears to be that the landlord, the actual private landlord, has already served notice on the agent, perhaps, the provider of your current temporary accommodation. So it would seem that actually, in fact, what happened is Cress Manor may have been served by some form of notice from the landlord already, and that's now resulted in Cress Manor providing notice to Mr. Cifci. What we do know, of course, is the operative date is the 15th of January 2022. So 7, supplementary bundle 7, we see the offer of Brighton Road. Now, you'll see the date here is important. It's on the 14th of January, so it's the day before the notice expires. It's a Friday. There is a legal technicality in the first paragraph that I don't believe we need to concern the court with, which is some modifications that were made to the statutory scheme in the 2017 Homelessness Prevention Act, which refers to relief duties, etc. The critical point here is that at this stage, the London Borough of Bromley consider itself to be subject to the full housing duty in relation to certificate.
And I'm sure it doesn't matter, but this is the first time they say they're accepting the main duty, is it?
It's certainly possible that's correct. I don't actually have the material available to me to confirm that unequivocally. It would make sense if that was the case,
Yeah.
even though he's been in temporary accommodation for years and this is normally supposed to happen after a much shorter period of time. But I don't believe anything arises from that. What is perhaps of some materiality is the second sentence in the letter. Wherever possible, we will make offers in advance of someone's homelessness date, and in discharge of the above duty, we're offering you the below accommodation. Okay. And then just turning down to the top of page 8. You see that this offer is made on the premise that Mr. Cifci will accept it and move in that day by 5 p.m. that day. So you can see there's an attempt by Bromley to honour the notice to quit and ensure that Mr. Cifci is out of the property, 22 Church Road, before the notice expires. It's also right to point out that, as is required by the law, London Borough of Bromley at the bottom of page 8 give Mr. Cifci the warning that it's the case that this is an offer which the council considered to be suitable, and if it's refused, it will result in the discharge of duty.
And indeed, they give the further warning on the next page.
Indeed. All of that again is uncontentious.
Yes.
And what we see from supplementary bundle 15, to complete this story, this is some of the same material that the learned judge was looking at, of course. We don't have everything, but we see an email to Mr. Cifci from Mrs. Bridget Venables, written on 17th of January, early in the morning.
This is Monday.
Yes. And it's just a convenient place to see the story as it developed, at least from the perspective of Bromley, which Mr. Cifci had gone on the 14th to find the property wasn't, in his view at least, in a fit state for him to move into. Keeping in mind he was being asked to move in that day, and keeping in mind he had various concerns about his wife's health. We do see some reference to that in the paragraph, in the email immediately above it. And we also see an internal email written on the 14th of January itself. And probably I should have taken you to this one first, apologies. To Bridget from a Jyothi, from it would appear the provider of the Brighton Road property, and the contents of that are self-explanatory. There seems to be an unfortunate incident where Mr. Cifci goes to the property and finds it, in the words of Jyothi, a little messed, and that then causes him to take the view that he can't move into that property. And then we see the email on the 17th saying, well, we appreciate all that and we're sorry about it, but the property is now available for you. Can you please accept it by 2 p.m. today and confirm that you have moved in? So he's given until 2 p.m. to move his family to this property, which he does not do. But again, one can see in my submission from that urgency that this is consistent with London Borough of Bromley being very concerned to ensure he vacates 22 Church Road as soon as possible. Of course, Mr. Cifci doesn't do that. He doesn't move in. And then we look at supplementary bundle page 25, where we see the discharge of duty letter.
And it just for completeness, you see the refusal of the offer at 16, don't you?
Yes, or at 24. The reason the one on 16, yes. In fact, we may as well just do it in the sequence. I was taking you to the discharge decision letter itself, but we can see the email which that was attached to on page
Yeah.
17. And this has the critical paragraph in it, which is one which is repeated word for word in the decision letter itself, the discharge decision letter itself. So there's no doubt at all that the reason for the discharge of duty is the refusal of the offer of right.
And you did take us to 25 as well, didn't you? Which is the formal letter.
Indeed. And that's what the writer of this email, Jake Regan, is referring to in his first paragraph.
Yeah.
And it's the following paragraph which is particularly material. And as I say, that's also repeated in the discharge of duty decision letter itself on page 17. Ordinarily, in light of a refusal of suitable temporary accommodation, we would give our clients 28 days to vacate their current property. However, this will not be possible in your case, as your lease deadline, your lease end deadline to vacate the property has already passed. You should immediately vacate the property and make your own housing arrangements. If you are not going to be able to do this, please advise me by email. Once they advise you to look for alternative accommodation and reminding him of his right to request a review of the decision. And then we see below that Mr. Cifci's email in response. So the email, the 17th of January, we're looking at is sent at 17:09. And Mr. Cifci responds the next day at 13:06. Says, many thanks for your email and response. We are not able to vacate our property immediately as we have nowhere to go. It explains how difficult that is for him and his family. Therefore, we'd be grateful if you could offer us more suitable housing. He responds separately to Bridget, explaining again his reasons for not accepting Brighton Road. Then what we see at supplementary bundle page 18 is an offer of temporary accommodation at 4 p.m. on the 19th of January. That's the High Street temporary accommodation for a period of 28 days.
See that I wasn't really up to. Have we got that off a letter?
It's LB 28. And again, repeats the point that you've been made this offer because it's not possible for you to stay at 22 Church Road. So, my lady, my lords, it's when one analyses those documents that we say that it wasn't open for the authority to conclude that the appellant ceased to occupy 22 Church Road because of his own deliberate act. Even if one agrees that he left on the 19th of January because he'd been told by the London Borough government to leave and they'd offered him alternative accommodation High Street, the only reason he was offered that was because in lieu of the expiry of the notice to vacate, it was not possible for the family to remain at 22 Church Road, as would have been standard practice. Therefore, despite the discharge of duty, he would have remained at 22 Church Road if it was possible for him to do so. But it wasn't possible for him to do so, precisely because of the reason expressed in the letter of the 17th of January. The notice of vacation, or the period of notice of vacation, had already expired. only tenable finding of fact is that the cessation of occupation was not because of the discharge of duty, but was because of the landlord's notice, which of course Mr. Cifci was not responsible. This is what distinguishes this case from the case relied on by my learned friend, which is the Dodson and London Council case, which one finds behind tab 6, which is again the decision of Lord Justice Lewison in a very familiar scenario, but not the scenario that played out in this case.
So we don't need the supplemental bundle anymore.
We don't need it at this stage, no. So the Godson case begins at page 91, and the judgment of Lord Justice Lewison begins on page 94 of the authorities bundle. In this case, Mr. Godson was provided with what's described as emergency accommodation as 21C Bury Street on the day of his application while it investigated his claim. Mr. Godson was entitled to live there by virtue of a licence granted to him by Enfield. On the 28th of August 2012, it accepted that it owed Mr. Godson the full housing duty. And on the 25th of July 2013, so almost a year later, during which time he remained in occupation 21C Bury Street, Enfield made him an offer of a tenancy at 28B Church Street. He was told by Enfield that if he refused, the consequence would be that Enfield's housing duty under that section would cease. Despite that, Mr. Godson refused the offer of the tenancy. As a result of that refusal, Enfield purported to terminate its duty to Mr. Godson on the 5th of August 2013. Mr. Godson sought a review of that decision. On the 4th of October 2013, the review decision confirmed the original decision. Mr. Godson could have appealed to the county court against that review decision, but he did not. On the 21st of January 2014, Mr. Godson and his family were evicted from 21C Bury Road. There are a number of different issues in that case, which are actually set out by Lord Justice Lewison in paragraph 1. And you'll see the third of those is if the termination of the housing duty in the homeless person as a consequent eviction was caused by the homeless person's refusal of an offer of temporary accommodation, is he thereby rendered intentionally homeless? And to which we see answered in this case at paragraph 51 of the judgment, which is authorities bundle page 4. In this case, the immediate cause of Mr. Godson's homelessness was the council's decision to evict him from 21C Bury Street. Causation does not necessarily stop there. It is necessary to go on to ask what caused the council to take that step. The answer is because Mr. Godson deliberately refused a temporary accommodation from the And then the second stage of the analysis goes on to look at second stage highly analysis from Lord Reed. But the very straightforward difference here is that in the Godson case, Mr. Godson was occupying 21.3 Bury Street. No notice had been served on him by the landlord, which happened in fact to be the local authority. He then refused an offer of accommodation. The duty to provide him with further accommodation was discharged, and naturally, as a consequence, he was given notice by the landlord to leave. That's diametrically not this case. It was the notice itself which prompted the offer of alternative accommodation. That accommodation was refused and it led to a discharge decision. So despite the discharge decision, the local authority would have accommodated at 22 Church Road had it been possible to do so. But it was not, precisely because of the reason they stated, that the notice had expired. It's just impossible to connect the discharge of duty with the cessation of occupation of 22 Church Road. There is only one explanation for that, and that's the notice. And that's why that's what's explicitly referred to in the decision letter itself.
So can we just talk round things for a moment? So in Godson, he would have left anyway if he'd accepted the offer.
Yes.
But nevertheless, his refusal of the offer was the cause of his leaving.
Well, it was the cause of the discharge of duty. And then the next stage of the analysis is the local authority saying, well, we've discharged our duty to you, which means we no longer need to provide you with accommodation. Therefore, the accommodation we're providing you with is going to come to an end. And therefore, it does come to an end.
But it would have come to an end anyway if he'd accepted the offer.
Yes, but you're not permitted to entertain hypotheticals in that way. One has to look at the actual reason for the actual cessation of occupation at the time. And that's unequivocally the law from Din all the way through to Hiley, etc. So the only question really for the reviewing officer in this case, and indeed ultimately this court, is that fundamentally, what was the reason why London Borough of Bromley said you've got to leave 22 Church Road? Plainly wasn't the discharge of duty decision, because irrespective of that, they would have kept him there had it been possible to do so, but it wasn't because of the landlord's notice.
When you say irrespective of that, they would have kept him there, you mean they wouldn't have offered alternative accommodation?
No, they would have. But they wouldn't have given him the high street accommodation. No, they say so in terms. They say ordinarily.
Do you mean sorry the new temporary accommodation?
Yes, sorry.
You can't say whether or not they would have offered him the alternative accommodation at Brighton Road.
No, Brighton Road is obviously offered, for the reasons that it's offered. The failure to accept it clearly results in a discharge decision. That discharge decision would ordinarily result in the cessation of occupation of temporary accommodation that was being occupied. And in the normal type of case, that's what happens. And Godson is very much the normal type of case. There's no question of him having to leave 21 Bury Street pursuant to a notice before the discharge of duty.
But I'm quite follow how you say it's different, but in another sense, it sort of maps on in Godson. He has accommodation that he can occupy until he takes new accommodation. In fact, he refuses an offer, therefore the council says duty over, leave. Here, Mr. Cifci has accommodation which he's going to be able to continue to occupy until he takes a new accommodation.
Well, that's not material to the ultimate question as to why he ceased to occupy 22 Church Road. That's a second part of the analysis. You must be very
well.
careful not to
I'm
slip
still
into
on
that.
Church Road. He can go on occupying. Well, can he go on occupying Church Road till he takes the new accommodation?
That's a question about whether it was reasonable for him to continue to occupy. It's a completely different question from the one which we're being asked to address. Which is, let's put it that, let's say this was in the gift of the London Borough of Bromley. Let's say Mr. Cifci left because London Borough of Bromley told him to. Why did London Borough of Bromley tell him to leave 22 Church Road? I mean, they told us the answer in the letter, because it wasn't possible for him to stay there.
So is that your central point of distinction? In either case, Bromley, the local authority tells the person to leave. You say in the one case they tell him to leave because he has declined the alternative accommodation. In the other case, they tell him to leave because the landlord wants the property back. Can it alternatively be said, well, actually, they require him to leave at that point because he's turned down the offer?
No, because that's not what happened. I mean, they clearly say, we've discharged, and normally you'd be allowed to stay where you are.
Well, they don't say that, do they?
Yes.
Well,
They say ordinarily,
yes.
you'd stay where you are for 28 days. That's what we do in a discharge case. We're not doing that here because you can't stay where you are. You've got to go. Vacate immediately. Why? Because the landlord's notice has expired. So they are not in fact proposing to stop accommodating him. They're proposing to carry on accommodating him. the point is they can't do it 22 Church Road simply because of the landlord's notice. Now, keeping in mind, my lady, my lords, that this all started with the landlord's notice. The first domino that falls in this case that ultimately leads to the cessation of occupation of 22 Church Road is the notice. And London Borough of Bromley then say, well, we've got to do something before the notice expires, and indeed they do, immediately before it expires. And then because of the, for want of a better expression, cock up in relation to the property itself, it carries over until Monday. And then on Monday they say, you got to go, you've got till 2 o'clock to accept this. And he says, I can't. And at that point they say, we're discharging our duty, we'd let you stay where you are for 28 days ordinarily, but we can't because of the notice. So on the strict question of causation in this case, on first link causation, there is only one explanation as to why he had to leave 22 Church Road. It's the notice. It can't be the discharge decision, because the discharge decision doesn't lead to that decision by Bromley. It leads to a different one, which is we'll carry on accommodating you, but we can't do it there. And why there's a temptation, if I may say so, to try and not necessarily ignore that, but leap over it, is because it's simultaneously true that if we were in the second stage of the analysis for Hiley, there would be no problem for the local authority concluding, well, you know, you're homeless today because you didn't accept that Brighton Road property. And indeed, that may well be true. And in our submission, that's really what's induced both the local authority and, if I may say so, the learned judge below, to reach the conclusions that they did. But they're unnecessarily strained. I'm going to say something about the purpose of the Act in due course. But
I mean, just talking, I know you're coming to the purpose of the Act, which is, so I'm taking out of your course, but just
No, not
talking
at all.
around it for a moment. As things played out, Bromley's duty came to an end,
Yes.
and whether or not you could say that Mr. Cifci was intentionally homeless at that stage, Bromley was under no duty. Is that right?
Well, there's a number of questions that can answer. What do you mean? Well, there's no duty under Section 193. To be frank, actually, they were still under a duty which has arisen through common law interpretation of reasonableness, which is a case called a jury number 5 that my learned friend and I are unfortunately old enough to remember, which says if you terminate a duty, you can't bring it to an end forthwith. You need to give 28 days notice for people to continue to occupy it.
Well, let's go
So
beyond
that
the
could be
28 days.
Yeah.
Come March or whatever,
Yes.
Bromley's duty has come to an end. Regardless of whether Mr. Cifci became intentionally homeless, that's that, so far as Bromley is concerned. They don't have to go back to Section 184 again.
If he reapplied to Bromley, they absolutely would have had to do that, yes.
But absent a change of circumstances, he'd have got nowhere.
No, incorrect. They would have had to determine whether or not he was intentionally homeless. Exactly the same issue would have arisen for Bromley as arisen for London Borough of Sutton. I am
Okay, yes, we do need to understand.
I mean, my learned friend and I have already discussed that. I think we have an agreed position, but insofar as there was a concession made in the court below that if this application had been made to Bromley and not Sutton, that would have been, the discharge of duty would have been the end of the matter. That is categorically wrong, and it's coming on to why I withdraw that concession. Absolutely, London Borough of Bromley would have had to ask exactly the same question, and in my submission would have been bound to reach the same conclusion. I'm also going to say in due course why that causes no problem with the purpose of this Act whatsoever. But what I stress, and if I may respectfully say so, I detect a degree of that in my Lord's questions. It's hard to come to terms with this feature of this case, which is, if you only accept Brighton Road, you've never been homeless at all. And that is probably true. But what's equally true, incontrovertibly true in our view, is that the reason Bromley say to him, leave, when they say leave, is not because of discharge of duty, it's because he can't stay where he is, because of the landlord's notice, for which he's not responsible. So if you use the Lord Justice Lewison paragraph 51 approach, he says, well, the immediate cause is the eviction. Our case, immediate cause is Bromley say, leave. What's the reason for that? In Godson, it's because they've discharged their duty, and it follows on ipso facto, because it's a classic type of case. That's not the case here. It's a causation analysis. It's only a causation analysis. And you cannot say the discharge duty led to it, because they actually explicitly say, despite the discharge of duty, we would have allowed you to stay where you are, were it not for the fact the landlord has terminated notice and it's expired, explicitly.
The trouble is the results should be the same.
In my submission, they should not, and I will come on to that. They really should not. That's the risk, that's the danger, if I may say so, my lord. We rely on a December case as a good indicator. I'm just flagging it for now.
Yeah.
Where somebody obtained a tenancy through blatant fraud. They used a false passport to obtain a tenancy, council tenancy. And of course, when that was disclosed to be a fraud, and at the point of that being disclosed, the local authority necessarily sought possession. When she applied as homeless when she was evicted, the local authority necessarily reached for an intentionality decision. You defrauded us, you got a tenancy, we discovered the fraud, you lost the tenancy. You're homeless because of the fraud. Lord Justice Lewison again said, no, unfortunately you must apply these provisions as they are set out. It's a causation question. Had you not committed the fraud, you would never have had the tenancy. Despite the bad conduct, despite the purpose of the Act, causation is causation. It actually, it's significant in this case for another reason. I mean, there's, again, just to highlight a particular way in which Lord Justice Lewison approaches this, if we could look at paragraph 9 of the December decision, which is at AD 55. So he's discussing in these paragraphs causation itself. It says, in some cases, the chain of causation will be linear. As Mr. Jan Luber, QC, hearing with Mr. Edward Fitzpatrick from Mr. Shishenda puts it, if a series of dominoes falls over, it does not matter that the applicant did not knock over the last domino if he set the domino effect in motion. In such a case, the control mechanism is that of the objective likelihood at the date of the deliberate act or omission that homelessness will be the end result. The trouble here is it's just unequivocally the case that the dominoes in this case are set in motion by the notice. They start with the notice and they end with the notice. And with the greatest respect to the reviewing officer and indeed the learned judge below and indeed this court, we are stuck with that. There's just no way in which one can manufacture a reason which says, despite the local authority, Bromley, saying in terms, despite the discharge of decision, we keep you where you are ordinarily, but we can't in your case because of the fact of the notice. It's just an incontrovertible fact. And that's why...
Just to understand, the normal arrangement to keep them in place, that reflects the 28-day rule. In which case, in this case, they discharged that duty by relocating the family to a property in Sutton.
Precisely because they couldn't keep him where he was, not for some other reason, not for some property management reason or something like that. We've got the words themselves in terms because the notice. Well, let's look at them again. I said we could leave the supplementary bundle, but perhaps this is just too important to skirt over. Thank you. Or we see it in the email itself at 17. Oh no, that's not what I want. 17 is what I want. But this is the one that's repeated in the answer. Ordinarily, in light of a refusal of suitable temporary accommodation, we would give our clients 28 days to vacate their current property. However, this will not be possible. In your case, as your lease end deadline to vacate the property has already passed. And this doesn't come out of the blue. This comes out of a local authority which at the outset says you've been given notice, we will accommodate you before the notice expires. Then they make the offer Brighton Road and say, we tried to do this before the date of your homelessness, which we know to be the following day when the notice expires. Then on the Monday after the events over the weekend, it goes wrong. They say, vacate, well, please now accept it by 2 o'clock today. And when he says no, the same day they say, leave immediately because of the notice. We can't ignore these facts. They are what they are. And they mean Mr. Cifci was not intentionally homeless because he did not cease to occupy 22 Church Road because of the refusal or indeed the subsequent discharge duty decision. And whether you apply Lord Justice Lewison's approach in Godson, paragraph 51. Okay, what was the actual reason for the decision of the council to evict? Or whether or not you look at the domino effect, as he so describes it, on the basis of Mr. Jan Luber's submissions in December, paragraph 9, you come to the same ultimate conclusion. And it's probably important to point out at this stage, so did the learned judge, His Honour Judge Holmes. He rejected the respondent's case that these facts disclosed multiple causes of the cessation of occupation, 22 Church Road. He said there was one cause, which was the landlord's notice. You can see that paragraph 26 of his judgment, which is a core bundle, page 67.
Sorry, which paragraph?
26, well, 26 and 27. So he responds to the submission made by the respondent that this is a multiple causes case. But just pausing there for a moment, it's an observation worth making that, and this is the one rejected by the judge, if it's nothing else, it's not a multiple causes case, it's one or the other. Either Bromley said leave because he discharged you, or Bromley said leave because he noticed you. There's no way in which those two can be considered to be multiple causes, and the Watchman case offers absolutely no support for that analysis either. I'll take you to that in just a moment, but it's important to note at this stage, after full argument before him, the learned judge felt unable to accept that, and it says so in terms.
Sorry, did you say 26?
26 and 27, I'm very sorry, my lady. So do you see he introduces the idea of multiple causes, or competing causes, and then 27, Watchman is focused on a different issue, namely which of several potential causes was the substantial cause of homelessness. The question here is whether it's the notice to quit or the refusal of the alternative accommodation which causes the loss of accommodation. And then you see his answer to that.
Is it so clear you couldn't have more than one cause here?
In my submission, absolutely. Again, we cannot get around this fact that despite the notice, despite the discharge of duty case, the decision, that doesn't lead Bromley to say we're going to stop occupying, providing with accommodation, including Church Road. It says the exact opposite. The counterfactual of the fact that we would have to move anyway if you'd accepted Brighton Road is neither here nor there, as indeed the learned judge also found below. And as the learned judge said at paragraph 30, the immediate cause of his leaving Church Road was that the landlord wanted the property back. And therefore, the dicta of Lord Justice Laws and Watchmen simply didn't apply. We can have a quick look at Watchmen. Because it's the page.
I mean, obviously, no one is actually defending the judge's reasoning in the end.
I'm defending this part of it.
You're defending this part of it, but you're not even defending the whole of paragraph 30, are you?
Well, as observations of fact, by and large, these are true.
I mean, once Mr. Cifci had refused, he ceased to have benefit in Section 193 duty. It was at this moment that he ceased to have accommodation available to him. Well, that you don't say, do you?
Well, yeah, you're right insofar as we don't agree with that because there is the notice period accommodation, which, as I pointed out, was in fact the form of a duty. What the learned judge is plainly referring to there, and we know this from how he then reasons out from the decision, is that the right to accommodation under Section 193 had come to an end.
Yes.
And he says that's good enough for the purposes of the definition in Section 191. That's the part of the reasoning that I would be criticising, but I don't detect any enthusiasm from my learned friend to uphold it. It's plainly wrong by reference to a simple analysis of the provision, because it's basically saying you can be intentionally homeless because of a failure to take up accommodation, rather than the cessation of occupation of accommodation you're actually in. And that's been the position of homelessness law for forever. It's always been an absolute golden principle of intentional homelessness, that you can't be intentional homeless because you fail to take something up. And if one thinks about it for a short while, one sees why that's the case. It gets incredibly nebulous to start thinking about, well, perhaps you could have taken up that offer of accommodation from your family member, or perhaps you should have asked your family member if they could put you up with accommodation. The inquiry, the investigation just gets broader and broader, which is one of the criticisms we make in this case. If you untether the question of homelessness from the loss of actual accommodation actually being occupied, you're in a morass of facts.
And that's what the judge did, but that isn't being defended.
As I understand it. So we say whichever approach you take to causation, in any of the cases, you come back to the same incontrovertible conclusion, that the reason the family left when they left was ultimately because of the landlord's notice and not because of the refusal. We say for that reason, the right conclusion on ground one is a variation. There are two remaining points I wanted to highlight under ground one of which, perhaps both of which I've foreshadowed. But on the question of the purpose of the provisions for intentional homelessness, this is relied on by my learned friend, and that's at paragraph 43 of their skeleton. And I confess it's to a degree understandable for the reasons that I've already said. If you were looking at the highly second stage causation question, the answer would come back that the refusal to accept Brighton Road was indeed the operative cause of the current state of homelessness. But we just don't get to that part of the analysis. And we don't get there for an important reason, which, as I've already said, and I don't want to labour, that in fact there is no deliberate act from which it's clear the consequence was the family had to, or did indeed, cease occupying 22 Church Road. And it is that fact, the incontrovertible fact, which in my submission explains why in the review decision itself there are many more references ultimately to the state of homelessness rather than the loss of the accommodation. That's indicative of the extent to which the reviewing officer was induced by that observation about second stage highly analysis. But whilst that sentiment is understandable, it is misplaced, as I've already said, for as long as these provisions have been on the statute book. It's always required there to be a culpable loss of accommodation actually occupied, which meets the requirements of the section. Failure to take up an offer of suitable accommodation, no matter how unreasonable, has never been considered sufficient. That's a policy decision we cannot interfere with. And therefore probably understood that Mr. Cifci is not queue jumping in any way whatsoever. He simply was effectively homeless already when he refused the offer of Brighton Road. But in any event, as is abundantly clear from the correspondence from Bromley, the reason why Bromley asked him to leave was because the landlord had served notice and he was not responsible for that.
Sorry, should we read anything into your reference to effectively homeless when he refused?
No, because as I'll come on to explain in relation to round two, reasonable to continue to occupy, strictly speaking, he probably didn't meet the statutory definition of being homeless. And because when one analyses this case on the premise, contrary to the appellant's case, that in fact it was the discharge of duty that led to the cessation of occupation, not the landlord's notice, then you only ask the question about reasonable to continue to occupy by reference to the facts, as if that deliberate act had not occurred. And what are those facts? Well, those are the facts when Mr. Cifci didn't refuse Brighton Road, and therefore for how long did that accommodation have to be reasonable for him to continue to occupy it? A couple of hours. From the re-offer made on the 17th of January in the morning to take it up by 2 p.m. that day. Now, I'm now getting into my ground two.
And you had another point to make on
I did.
Ground
yeah.
one
What should I
before
do
you-
first.
No, please, I don't want to take you out of your course.
Okay, well, if I can leave that there where it was, I don't have much more to say about either of these, thankfully. My second point was about, sorry, just to finish on the first then about the purpose of the Act. I do think it's important to highlight the Cifci decision, because if ever there was a case where one might have said the purpose of the Act should lead to a strained outcome on the facts, it was Cifci. There's just nothing positive to say about the conduct of the individual at all, but ultimately she could not be found to be intentionally homeless.
I mean, in broad terms, here, you say, well, actually, Mr. Cifci could have gone back to Bromley, and they wouldn't have been entitled to say that he was intentionally homeless, with the result that presumably they would have ended up accepting that they owed the Section 193 duty.
My second point, yes.
Oh, I see. Okay. Let me leave you to develop your second point, and then.
So Cifci is my reference point. You know, we're miles out here on Cifci, it's still unintentionally homeless. We're nowhere near that in terms of degrees of culpability in this case, in my submission, and therefore there is no sort of overarching imperative to find a solution, in my view. The outcome need not be the same, to answer my Lord Justice Newey's explicit question to me. So the second point is, at 23, paragraph 23 of the judge, the learned judge highlighted a concession that was made by the appellant below, namely that if Mr. Cifci had made subsequent applications to London Borough of Bromley, as opposed to London Borough of Sutton, then the discharge of duty would have been a, quote, complete answer to that application. And my learned friend, I wouldn't say relied on, but refers to that concession of paragraph 42 of this. That is unequivocally incorrect, and I withdraw that concession now. What the case law plainly establishes is that, save in circumstances where the subsequent application is on identical facts to the previous application, in which case there is, properly speaking, no fresh application at all, Section 1939 applies. Section 1939 is, of course, in your authorities bundle. Page 136.
So, how would that play out here?
So how it will play out here, my lady, is that once the Cifci family ceased to occupy the accommodation that they were provided with by the London Borough of Bromley,
The 28-day
indeed,
accommodation.
they would then actually be homeless again, a new instance of homelessness. And London Borough were charged with inquiring into that application and determining whether or not they were in priority need and unintentionally homeless. Now, of course, you have cases where, for example, priority need has fallen away in the interim.
Sorry, and why do you say that's a new, that is a fresh
That would
application?
unequivocally be a fresh application.
Because they are actually now homeless.
Yeah, it's a new fact which wasn't present previously, and there are two cases where I say that is
So
made
just be clear, you're back to Section 184 on that thesis.
Yes, indeed, absolutely. And it's really important, therefore, to that question, my lord. It's not a repeat of the lost review on suitability. That's not the issue. In fact, it wouldn't have been possible for Mr. Cifci to say that. He wouldn't have been able to say in the new application, oh, it was unsuitable, because that would be trying to repeat an argument that he could have made by way of a review and appeal against the decision of London Borough of Bromley, 17th of January, that the offer Bright Road was one of suitable accommodation. But he absolutely could have run the points that have been run in this application to Sutton and are being run again here today, which was that he, despite the refusal of Bright Road, he wasn't unintentionally homeless. And for our arguments, and in our submission, the conclusion would have to have been the same.
So, just understanding then the logical consequences of that.
Yeah.
Would it be be the case that every time a landlord or social housing landlord says you've got to leave this property, and the tenant does not like the alternative property that the council offers, they can benefit from the 28-day leeway that you explained earlier, then become homeless and then start again.
Yes. And
In every case, it's not just a case of moving boroughs, which is what the concession below.
So that certainly is
suggested.
true. It's certainly not a case of moving boroughs. The reality of the situation is, though, that in the type of scenario you just posited, my lady, or in the Godson scenario, intentionality was a given.
No, it's not the Godson scenario. I said, let's assume it's a third party
see.
landlord. Closer to the facts of this case, it's
Yeah.
not the council decide, but this must happen all the time for whatever reason. The property is going to be redeveloped, used for other purposes, whatever it is.
My lady, I apologise. In your scenario, the property that's being initially occupied,
Yes.
I think you mentioned might be social housing.
Well, it might be a social landlord, but for whatever reason, good independent reason, that property is no longer going to be available.
Unrelated to a deliberate act.
Unrelated to an
Yes.
act. So I'm just trying to understand the consequences of what you say is the correct.
Okay, forgive me once more.
analysis.
Are you saying there's no intentional conduct in relation to the second accommodation?
There's a refusal to accept the alternative offer. So, as in this case, the council.
Right. So,
I mean, there's positive. The first property was temporary accommodation, as here. So
Yes.
say people can stay in it for years.
so they've been put in there by the local authority?
Yes,
Yes.
there is a continuing housing duty.
Yes,
The landlord says, no, I want the property back.
yes.
The council says, well, there's another property in the next street, you can have that.
Yes,
And they say, no,
yes,
they don't move in, they don't request a suitability review.
yes.
In every case, they could, after the 28 days, on your arguments, make a fresh application.
Well, in that scenario, there could be no question of them being intentionally homeless at all. But why would it be a fresh? It would be a first application, would it not? I'm sorry if I'm being.
Well, you have to assume. I'm just repeating the facts of this case.
Okay.
They've refused to accept the property in the next street. The council say our housing duty is over.
Yes. They then are.
Accommodate you at our discretion for 28 days.
Then they're actually evicted, or that accommodation.
That suggests to me it's not accommodation for a discretion for 28 days. The subsequent homelessness inevitably leads to a fresh application in all cases.
Well, that is the Godson case. Yeah, that's exactly what happened. They made an application which ultimately reached the conclusion he was intentionally homeless. So yes, in that scenario, insofar as you want to describe that as a fresh application, then yes, that's absolutely unequivocally the case. And indeed, in the case law which establishes the right to make repeat applications consistent with section 1939, which is the Rika Begum case, which followed on from an earlier case, they grapple with all of those practical implications and nevertheless conclude that it doesn't require material change of circumstances. It simply requires some new fact. And it's unequivocally the case that if you've subsequently become homeless again, even if one of the reasons why you've become homeless again, or the reason you become homeless again, is because a previous duty was discharged in relation to you, you still have every right to have your application determined. Unequivocally true.
So let me just bring it back to accommodation provided by the local authority. So suppose Bromley had itself got accommodation and had accommodated Mr. Cifci and his family in the accommodation, and had then decided that it would be better that they went elsewhere and said, we're offering you this alternative accommodation. Is that different? I mean, if he then refuses the alternative accommodation, Why is that different?
Can I just pause for a second to say there is some risk if we explore hypothetical scenarios too much, only because you don't have the cases on fresh applications before you. My learned friend and I now agree that, I think at least, that the right to make an application would certainly be there, certainly if they'd actually left the accommodation on the high street, which of course they did. So if they'd applied at the time they applied to Sutton, there's no question at all Bromley would have had to consider that application. If that feels unsatisfactory, in my submission, it isn't at all, because this is the first time the question of intentional homelessness arising from the refusal of the alternative accommodation would be considered at all. There has never been a decision on that question. Do you follow?
But on your case,
Yes.
Bromley would then have to decide that Mr. Cifci was not intentionally homeless.
Well, yes, for precisely the same reason London Borough of Bromley was obliged to.
No, quite. So fine, he can make a further application, but on your case, a further application will succeed because Mr. Cifci was not intentionally homeless.
Well,
So even though he was offered accommodation, turned down suitable accommodation, ex hypothesi, the duty to him came to an end under Section 193. Nevertheless, he can immediately reapply on the basis that there's a new fact, and Bromley will inevitably find that they owe the duty again because they have to conclude that he was not intentionally homeless.
Yes, and that's not a surprising outcome if one keeps in mind, as I just mentioned a moment ago, that the question of causation for the loss of his accommodation is not a relevant consideration from any decision made by Bromley prior thereto. There's no one required to ask that question until such time as a fresh application is made, which is precisely why the concession, which was framed this way, the mere fact of the discharge of duty decision would have meant there could be no subsequent application, is plainly wrong, with the greatest respect to my lone junior behind me. It clearly would have had to be determined, and it would also have been determining a question fresh for the first time, which is this person, in light of that refusal of the offer, intentionally homeless?
But that subverts the discharge of the duty that you find in Section 193.
My lord, it does not.
Because the reason that the duty was discharged was the refusal of the accommodation. And now it turns out that regardless of that, the local authority owes the same duty.
And would allow successive refusals of alternative accommodation.
No, because this
Why not?
particular scenario is an unusual one where the landlord's notice is what drove the cessation of occupation.
Yeah, but can't we apply that to the 28-day leeway that you mentioned? So if they were put into, the family was put into or kept for 28 days in accommodation that was only available for 28 days, the same point repeats itself.
No, because it was only available for 28 days because of the discharge decision.
So take, maybe this is a clearer case. So the local authority has a block of flats that it wants to demolish.
Yeah.
It has a family in one of the flats.
Yeah.
It says the demolition people are coming in next week. But that's fine because we're offering you alternative accommodation. Alternative suitable accommodation. That's turned down.
Yes.
Necessarily, it will find itself owing the same duty again.
Potentially, yes.
You're saying potentially, necessarily, in fact.
If what pans out is that the block of flats that's to be demolished is in fact demolished and the family are evicted.
Yes.
Well, I think there's some risk at speculating too much about the substantive decision on intentionality. I'm very happy to keep answering questions on that. I'm just somewhat aware of the fact you don't actually have the cases on fresh applications in front of you.
But I'm quite.
I know you're trying to.
I know. I think I can't remember the detail, but I have had a fresh application case, and it's a pretty low threshold. You're right, but that's not really the point.
Yes.
The point is, okay, you can make the fresh application, and on your case, you find that you're owed the duty again. And that's what seems
So
anomalous.
we have a precise example of this in the authorities. It's the case of R on the application of Kensington and Chelsea versus Ealing. And in that case, what happened is Ealing discharged a duty to somebody because they refused an offer of accommodation. They then applied to Kensington and Chelsea.
Sorry.
Which tab?
It's not in the tabs.
Oh, I see. Yes,
I'm sorry, that's why we're in this position.
Yeah, sorry.
I know maybe the old answer to this may be some written submissions on this, if insofar as the court wants to explore these scenarios.
So give us the name of the case again.
It's R on the application of Kensington and Chelsea Royal Borough Council versus Ealing London Borough Council, 2017 PTSR. PTSR 1029.
Yeah.
It's a decision of the High Court, but it's effectively a scenario where in our, well, let's try to not deal with the facts too specifically, but in essence what happened is Enfield say, there's your offer, applicant says, don't want it, Enfield say, discharge duty, applicant go to Kensington and Chelsea obliged to take the application in the same way that Sutton was, and determine that unintentionally homeless and therefore full duty owed, but because there's a local connection with Enfield, referred under the referral provisions back to Enfield. Enfield said, wait a minute, we've discharged duty to this person, we refuse to accept the referral. And effectively what was argued was that by virtue of the fact she's applied to Kensington and Chelsea, we've been disadvantaged as London Borough of Enfield. And the court said, no, you haven't. You would have been similarly stuck with the unintentional finding in the same way that Kensington and Chelsea was. It's just a question of causation that must be determined on the particular facts. It's highly unusual to find a case of this kind because the normal case is the normal scenario in Godson. It's much more normal. You don't have this independent reason why the particular accommodation has to come to an end and does indeed come to an end at a particular point in time, which actually explains why that accommodation is not being occupied.
It's a pretty accidental difference.
But, my lord, it is not.
In either case, the truth is that the person has to leave because they've turned down an offer of alternative accommodation.
No, in this case, they do not have to leave because they've turned down an offer.
No.
I mean, I can only keep saying this, and I don't want to labour it, but we are stuck with those facts, and it causes no problem with the purpose of the Act because the accommodation that was lost through no action of Mr. Cifci. You are, if I may say so, falling for the same seductive analysis which says, but your ultimate homelessness was down to this. And the scenarios we're positing are the same. We're saying, but wait a minute, we've discharged duty by offering an offer.
What I am concerned with, I know you say it's an unusual scenario, but it doesn't feel unusual that for some external reason, property is no longer available.
Yes.
Let's say it's just not suitable, it's too dilapidated.
And now we're getting to a very...
Okay, all right. Let's say it's okay. Let's stick with landlord notice to quit, which can't be unusual because so much property is let from third parties, and the council must resort to that sort of temporary accommodation. If I've understood you correctly, in that, if there's that element at the start of the dominoes, as you describe it, then there could be successive refusals to accept offers of alternative accommodation, leading to perhaps these periods of grace of 28 days, and then people are genuinely homeless and they start again. At no stage in that dominoes will you, on your argument, have identified an intentional act of a kind that triggers the provisions?
Not necessarily.
Because at no stage is the refusal on that set of scenarios, at no stage is the refusal of the alternative accommodation ever causative of the ceasing to occupy.
Well, I'm not prepared to accept that on facts which are not before us. It's not inevitable. You are, in this case, you have the decision made when it's made and for the reasons that it's made. and we have those in black and white in front of us, and we can't ignore them. The scenarios you're positing, my lady, if I may say so, seem to potentially involve a scenario where the local authority are free to keep the person continuously in the property that is otherwise likely to eventually go back to a private landlord, pursuant to extended 28-day periods while they keep offering accommodation which is refused, and are unable to ever say enough's enough. And that's just not correct. They could, for example, try to find you intentionally homeless from the temporary accommodation if you ever take it up. But equally, it demonstrates, just in the very facts that you're suggesting, it's not the landlord's notice that's operative in that context. It's the decisions made by the local authority. But the decisions made by this local authority are not because of the discharge decision. They tell us that.
Just latching onto that.
Yeah.
On your case, the distinction isn't between decisions made by a third party and decisions made by a local authority.
No.
Because
the reasons for the local authorities.
If the local authority itself insisted on the person leaving for another reason, you say, well, the position would be the same.
No, I don't.
Sorry,
So-
if the local authority insisted on, if the local authority decided it wanted the property back, and the person offered alternative accommodation which was turned down, that would be the same as this case? I mean, it does the involvement of the third party in principle make any difference?
Well, insofar as on the facts, it seems to have dictated to the local authority what they felt able to do. The impossibility or the not possible reference isn't a reference to what was possible.
And I follow that on the facts, but in principle, if the local authority had arrived at a similar conclusion internally for its own reasons, the position would be the same.
In exactly these facts, in such a world where the council felt equally compelled to say, despite the fact we want to carry on accommodating you, we can't do it here, you've got to leave, for a reason unconnected to your own deliberate conduct, absolutely the answer is the same.
Yeah.
And if one thinks about that for a moment, one realises it's perfectly sensible and consistent with the Act. You just haven't made yourself homeless. What you have done is refused an offer of alternative accommodation. But that does not justify finding you intentional homelessness. It never has, and it never will. And this is exactly why the learned judge below came up with a somewhat elegant but ultimately misguided solution, because he, too, with respect, appreciated the facts were the facts. And the cause of the loss of the accommodation at Church Road was the notice, because that's exactly what Bonnie said. And therefore he looked for a different solution, rejecting the submissions made by the local authority. What I'm at pains to try to do, and I'm perhaps not succeeding very much, is to explain to you why this is really not so problematic for the grand scheme of the Act at all. Unless you start entertaining the possibility that people should be capable of being found to be intentionally homeless merely because they refuse an offer of alternative accommodation, which is not the law. And there are many cases, frankly, I can say this without straying into evidence giving, where the normal Godson scenario is what happens. They're perfectly happily going along in the temporary accommodation, they refuse an offer, and then temporary accommodation is brought to an end precisely because of the discharge of duty. In those scenarios, they absolutely can make a fresh application once they're evicted, because that's a new fact. And just as Mr. Godson found, they're liable to find that they're intentionally homeless without any response. Not because they didn't take up the offer, but because they lost the temporary accommodation because they didn't take up the offer. That's just not our case. And I don't accept, I have to say openly, that there's something ordinary about this scenario. My submission is completely not ordinary. Everything is being driven by a landlord's notice that London Borough say at the outset there's nothing they can do about, as indeed does the agent, nothing we can do about this. And we must be very careful not to speculate about hypotheticals that didn't happen. We're not allowed to do that. House of Lords tell us that in Ginn, as reinforced by Lord Reed. So, frankly,
Sorry, that House of Lords references which
to the case of Dinn, which is discussed at length in the case of Hiley, and I'll give you those references. some extent the entire judgment, but
Well, we've got the reference in Hove.
yeah, it actually comes under the heading of DIN, I believe. Hang on. So from paragraph 31 onwards, on page 72, the authority fund are very grateful to my and indeed, I believe that, for what it's worth, the learned judge below also accepted and acknowledged that. It's neither here nor there, whether they might have had to leave church road anyway if they'd actually accepted the property. That does go to ground 2 reasonableness to continue to occupy, which is a completely separate question.
Is that where you have reached now?
That's where I've reached now. I just want to highlight, though, that it's not particularly satisfactory, and I take full responsibility for this, that we're looking at this question about fresh applications, fresh, without any cases in front of you, and without it being dealt with in the skeleton. I apologise for that. Ultimately, it's a peripheral question. It doesn't go, in my submission, to the interpretation of Section 191 at all.
I'm sure the test for a new application isn't crucial. The fact that you say you would inevitably find that you owed the 193 duty again
In a case like this
like
one.
this one is more surprising.
Well, in my submission, for all the reasons I've said, it isn't, but there's perhaps not much more
No,
necessarily
no.
to say about that, save to reinforce the point that a failure to take up occupation of accommodation cannot be
Yep.
a reason for finding intentionality.
Yes.
So on ground 2 then, first point, if you're with us on ground 1, there's no reason, indeed, I would urge you not to look at ground 2. It just gets very complicated to try and analyse reasonable to continue to occupy in circumstances where there's no deliberate act. What are we analysing? It's very difficult to do. This has never been a case where the question of whether it was reasonable to continue to occupy the accommodation in Church Road related to its physical characteristics or anything of that kind. It was only about the extent to which it could be reasonable to expect the family to stay there in circumstances where the landlord has said you've got to go, and where Bromley has said it's not possible for you to stay, and have said you've got to leave immediately. I'm going to take this reasonably swiftly to reach a conclusion which effectively says if you're not with me on ground 1, I'm going to struggle on ground 2. So let me preface it that way, but it's probably right that you have the analysis insofar as you want to go through it yourselves or deal with it. First of all, okay, so what is the actual decision we're concerned with on this second question, which, as I say, only arises if we lose on ground 1, and we look at core bundle page 121 again for that reasoning. It's D. Where it said, oh, well, we think it would be reasonable to stay there until possession order was obtained. We say that in light of 2 things, it's just an untenable finding. The first is London Borough of Bromley clearly thought very differently about the situation, so it wasn't possible for you to stay any longer at all. And the second is a brief reference to the Code of Guidance, which we see Authorities Bundle, page 162. Which is concerned with reasonable to continue to occupy in circumstances that actually really begins on, page 161, paragraph 6.29. Just to point out that these paragraphs are reference to reasonable to continue to occupy in the context of 175 of the Act, which is the question of whether somebody is homeless. But there is an alignment between the requirement that accommodation that's available to someone is reasonable to continue to occupy for the purposes of whether or not they're homeless, and also insofar as they may be intentionally homeless. And the paragraphs deal with the circumstances where a notice to quit or under an assured chokehold tenancy, a Section 21 notice has been served and has expired. And ultimately, the sort of conclusion of all of that is at 635. True it is, ultimately this is referencing an assured short-hold tenancy. We're not quite sure, but there's no evidence as to what tenancy in fact, that's Mr. Cifci's right, what in fact was available, what tenancy Mr. Cifci had at 22 Church Road. But for the principle, in my submission, it doesn't matter. Where you've got a situation where notice has been served, it's expired, there are no efforts underway to negotiate a period of extension by the local authority or indeed the applicant, and there would be no defence to a claim for possession, then it's unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of the notice. And just to reinforce how that principle is explained in shorthand, you've got Lord Reed in Highley at paragraph 14, which is authority bundle, page 68. It's actually in paragraph in the previous page, but the reference to the guidance we're looking at is there with the last sentence of page 67 and then going on to page 68. Whether or not an order for possession has been obtained should not be regarded as critical, where put shortly the landlord would give a notice and there would be no defence to an application for possession order. And just carrying that on to some degree, we've then got Lord Justice Lewison in December, paragraph 16, which is Authorities Bundle 57. Paragraph 17, I do apologise, still the same page, 57. Sorry, paragraph 19, where unfortunately page 57, Lord Justice Lewison is quoting Mr. Justice Wolfe, as he then was in the early case of Glidden. Albeit that's a reference to a scenario where the tenancy has been obtained as it was in December by deception. I say ultimately the principle is the same as articulated in the guidance. If you're in a position where notice has been served, you've got no conceivable defence, how can it be reasonable for you to continue to occupy? So that would be our ostensible case against the finding as articulated in paragraph D of the review decision. It's just not tenable to say it would be reasonable to continue to occupy until such date as a review decision, until such date as a possession order had been obtained. But to be fair to the reviewing officer and my learned friend, they seek to rely on another passage of the review decision, which we see at page 112.
122.
112. And it's right in the middle of that paragraph, beginning 22 Church Road. 22 Church Road remains available and reasonable for your continued occupation until Bromley Council offered 357 Brighton Road performance of that duty. Now, that's obviously correct to this extent that the offer itself came before the expiry of the notice, you may recall, came the day before. So it was obviously reasonable for the family to be able to remain there until the notice expired. Nobody would contend otherwise. However, when one goes back to that analysis I mentioned earlier, the Denton and Southwark case, and Lady Justice Arden, as she then was, if you're against me on ground one, you then have to ignore the fact that Mr. Cifci refused the offer of accommodation at Brighton Road, and then ask the question, would it have been reasonable for him to continue to occupy accommodation in those circumstances? And in my submission, that's where, if you're against me on ground one, I get into difficulties on ground two, because if we then look at Dodson again, and Lord Justice Lewison, paragraph 49, which is Authorities Bundle 103.
Paragraph 49.
Paragraph 49. And it's the last two sentences there. Can you see that? Now, the difference between these two cases, as I've mentioned many times, is that obviously in our case there was a notice to quit which had ended. But on the premise, but only on the premise, that you're against me on ground one, you're still required under Denton to ignore the fact that Mr. Cifci refused the offer of Brighton Road. And absent the notice for a moment, if you apply Lord Justice Lewison's approach in paragraph 49, you're left with the question, well, would it be reasonable to ask him to remain until 2 p.m. on Monday the 17th? Now, it's always a question of fact and degree. And in my submission, it would be difficult for me to maintain an argument that it was perverse or irrational to say he could have stayed there for an extra couple of hours. And that would apply to the notice had been served. And I don't really think the reviewing officer gets to that stage of the analysis. I could insist on saying, well, that's good enough for quashing on that point, but I don't want to take an overly technical point. If you can see, it's obvious what the answer would have been, then you're perfectly prepared to accept that. But one really does have to see the difference between these two scenarios. It's precisely why you must analyse ground one and ground two separately. There's very different questions. But if we lose on ground one, and we're stuck with a deliberate act, which must then be excluded from the consideration, one was asking the question, was it reasonable to continue to occupy in circumstances where he was going to accept Brighton Road? That would have meant staying there till 2 o'clock on the 17th. Of course, if you're with me on ground one, then there's no need to entertain these questions on that hypothesis. Now turn my back for a moment.
Please.
Well, my lady, my lords, unless I can assist further, those other submissions.
Thank you very much, Mr. Burton. Mr. Cifci.
Thank you, my lord. I'll begin, if I may, by just sort of correcting one sort of minor factual error that may have arisen. I think Lordship asked, did Bromley first notify the applicant that it's accepted the main duty when it made him the offer at Brighton Road in 2022? In fact, it accepted the main duty a lot prior to that, quite considerably. I think it's about 2018, but just so you know where I get that from, if I ask you to open up the core bundle at 110, if we turn to underneath last settled accommodation, so Bromley had accepted the main duty, and it's not a dispute that in fact 22 Church Road was provided in performance of that duty.
I see, yes.
And you'll see that also underneath availability of accommodation, that 22 Church Road was provided in performance of the section 193 temporary accommodation duty.
Sorry, I wasn't keeping up there. So
underneath, over the page at 111,
yep.
Underneath availability of accommodation, Bromley is on duty to provide you with accommodation.
I see, yes.
So where does it say the date the duty was accepted?
We don't have an exact date. We know the accommodation was provided in 2018. Possibly it could have been provided as section 118 to begin with. But that duty doesn't obviously last forever. You have to give somebody a decision on duty, and we do know that actually a duty was accepted because 22 Church Road was provided in performance of the main housing duty, and that's not in dispute. So I do say, although this is an appeal about section 191, I do say it's a significant feature of the facts that before the court today, that this was a case in which the main section 193 duty was accepted. So this was an applicant to whom another local authority, Bromley, had accepted the main section 193 duty, which is the full duty, and was accommodating initially in Church Road in performance of that duty, and then make an offer of Brighton Road. When Brighton Road is then refused, that's when they discharge duty. But to pick up on something your ladyship was asking my learned friend, and sort of the consequences of the appellant's analysis, I say it has very undesirable consequences under the Housing Act. If the appellant is right in their approach, so that the service of notice by a private landlord on accommodation A, and accommodation A being accommodation that's temporary accommodation provided under the Part 193 obligation, if a notice is served leading before alternative accommodation is secured, so we have the notice, after the notice alternative accommodation is secured, and the section 193 duty is then discharged following a refusal, on the appellant's analysis, that precludes a finding that an applicant can ever be intentionally homeless from the first accommodation, accommodation A. So that the only lawful conclusion to this authority, Sutton in this case, was that the appellant cannot be found to be intentionally homeless. I don't accept a proposition that such finding cannot be made. I do agree that you cannot find someone to be homeless intentionally from occupation they've never occupied. I accept that. But I certainly don't accept that you can't find someone to be intentionally homeless from another accommodation when they have refused a suitable offer of accommodation. So that's where we part company.
And just as to the proposition you were putting forward a moment ago, is that paragraph 40 of your skeleton?
Yeah, yes. So, my ladyship, back to the sort of scenario you were sort of posting earlier, what would be the consequences of the appellant's approach on this is correct? Again, I respectfully disagree with the suggestion that actually this is a very unusual set of facts. This happens all the time. As the housing market becomes more intense, there's more pressure on it, all public local authorities are increasingly going to private providers to secure accommodation to help them perform their housing functions. This isn't new, this has gone on for years. They go to a private provider, they say, will you make accommodation available to us? We will only use it in performance of our Part 7 duties. So they have some sort of licence with them, and then they grant sub-licence or sub-tenancies and non-secure tenancies to homelessness applicants. So I don't accept for a single minute that the set of facts that this court is looking at today is unusual. Having accepted a duty, a main housing duty, and having provided temporary accommodation performance of that duty, that temporary accommodation can cease to be available for all sorts of reasons. One of them can easily be a private landlord has served a notice, so that means that accommodation will no longer be available, and the local authority is then going to have to find something else because they're still under the continuing duty. But there's a whole host of other reasons. It might be a family's outgrown the temporary accommodation they were in, or it might be actually the needs of that family have changed. They were in a 7-bedroom accommodation, say, because they had a large family, but actually a couple of years later, their family composition has changed, their needs are no longer the same, but other applicants are coming through with large families and they now need a larger accommodation. So the local authority has to manage its stock somehow, and it might have to then look at moving the first family who are now in an accommodation that's too big for them into a smaller sized accommodation. It still has to be suitable, that duty never changes. But they do that so they can free up accommodation for someone else who's in greater need. That's just how the system works. Temporary accommodation might also be brought to an end or no longer considered desirable to offer because it can be very expensive. Nightly lets are very expensive for local authorities. They don't want to leave applicants in there for longer than they have to if there's other suitable accommodation, because of course they have to manage their budget and their resources. There's other reasons why applicants might be moved. It might be somebody's in temporary accommodation, they've fallen out with their neighbours, there's antisocial behaviour. A local authority could evict them and say, well, we no longer owe you a duty now because you're intentionally homeless as a result of that antisocial behaviour. Very often that doesn't actually happen. What a local authority might do first is move the family to a different accommodation, give them another chance. And the reasons for that are various. It might be that the family who's caused the antisocial behaviour, there might be mental health issues in play. So it might be the local authority doesn't simply want to discharge duty, it wants to give them another chance. So when a local authority does move, if I call them a main duty applicant, to somewhere else, and either they or private landlord serves notice to terminate, they have to provide suitable accommodation. On the appellant's case, an applicant is free to refuse that alternative offer and can then reapply almost immediately. And then, whether it's the same local authority or another local authority, are precluded from making a finding of intentional homelessness.
When you say almost immediately, do you have in mind that 28 days that we were
It could be the
talking
28
about?
days, it could be the minute they receive their notice telling them duty's being discharged. So an applicant who receives an offer, well, what do they do with the offer? Well, the respondent respectively says, well, really, it's quite clear. If you refuse a suitable offer, the Act makes it quite clear that you are at risk of duty being discharged because you're not entitled to endless offers, it's just one offer. So the obvious solution would be to accept the offer and request a suitability review. That way you don't become homeless. You've got somewhere to stay, and actually if you don't like the offer that's been made, you're not prejudiced because you can still seek that suitability review.
I mean, the snag here, as I understand it, is that Mr. Cifci didn't consult the CAB quickly enough, because I dare say the CAB would have said exactly that.
Possibly, but of course he was warned by Bromley about the consequences of refusal. So I say that's not an answer, I'm afraid. We all, very much sympathy we have, and we do have sympathy for these applicants. That's not an answer because he was warned. I mean, the appellant's really saying something quite different. What they're saying is if the applicant refuses the offer, and even if a local authority discharged duty in consequence of that refusal, the refusal is not in any way a causative factor of the homelessness. The cause was a thing, in other words, a notice that made the local authority make another offer. So then they can just apply again after a discharge. On the facts of this case, it was a different local authority, but it could easily be the same authority. So let's just sort of run with that as a scenario. An offer is made, it's suitable, and duty is discharged. So then the applicant just makes another offer. So what's the local authority to do? Let's say it's the same local authority for argument's sake. Well, the obvious thing to do would be to make the same offer again, because it's already decided it's suitable. Why invest money and resources in going off and looking for something different?
Well, except that's probably not available anymore.
Possibly, quite possibly. I mean, we know sometimes that local authorities do make offers available for longer than they perhaps need to avoid people refusing and then having no duty owed. But let's just say that duty is discharged, a letter's sent, and the very next day, or the same day, the applicant goes back to the authority and says, I'm homeless again. Why couldn't the local authority simply say, if that offer's still available, why not just say, well, we've already looked into your case, if this is a new application, we'll just make you the same offer. And then what happens? Presumably, the appellant refuses it again. That cannot be right. In my submission, that makes a mockery of the Act. So I say, when looking at issues of intentionality, it should be done in a way that reflects the statutory purpose and statutory intent of the provisions. So the respondent's position is that where there are potentially multiple causes of homelessness, and the respondent says this is such a case, it was reasonable in the facts of this case for this authority to find that actually the operative cause of the appellant's homelessness, and that's what we're concerned with, someone's homelessness. The operative cause of the homelessness was the refusal of an offer of accommodation. So that's my first sort of headline submission. My second headline submission on ground 2 is that it's reasonably open for Sutton to find that 22 Church Road was both available and reasonable for the applicant to continue to occupy whilst Bromley performed its Section 193 duty, and while that duty persisted, until such time as Bromley secured alternative suitable accommodation. And I can say that, and I'll sort of develop these submissions shortly. I can say that because available and reasonable to continue to occupy does not mean indefinitely or for any period of time, any particular period of time. So dealing with my first point,
This is the ground 1 point.
round 1 point. So this is really all about causation.
Yes.
So the appellant's case is Section 191 is directed towards the reasons why an applicant continue to occupy specific accommodation, and I agree with that. I don't seek to uphold the judge's reasonings, and I need to say no more about that. But where I say the appellant's approach falls down is, I say you can't just focus on one element of Section 191 at the expense of the true meaning, both of Section 191 itself, but also the purpose of the Act. So Section 191 is all about an applicant becoming homelessly intentional. I say that's the key thing. It's about an applicant who becomes homeless intentionally. Now, the appellant, and I don't say there's anything wrong with this as a starting point, the appellant breaks Section 191 down into its component parts, and there's nothing wrong with that. That's a good exercise, in fact, because that leads to a disciplined approach. So I don't have an issue with that. But what I do say, that's a helpful exercise, that's a good starting point, but having zoomed in on those individual parts, when it comes to making a decision, you then have to zoom out. You have to look at Section 191 as a whole. So what is the meaning of Section 191 as a whole? There won't be any dispute between myself and my learned friend on this. I mean, the broad thrust is to ascribe intentional homelessness to an applicant who, on the facts, is responsible for their state of homelessness as a result of their deliberate act or omission. And there won't be any disagreement on that.
And that comes from a case, doesn't it?
That comes from, you can see it, my lord, if you, it comes from Watchman. You'll find that in the authorities bundle at tab 2.
And it is or omission. It's not just positive that.
That's right, yes. So that's tab 2.
That must be paragraph 20.
Paragraph 20. And then we ask ourselves, well, why was that provision enacted? And again, this won't cause any sort of disagreement between the parties. The Act, Part 7, is all about relieving homelessness and assisting those in greater need, but also there's a degree of encouraging responsibility for our behaviour. Because there's not enough resources to help everybody who comes through the door, we have to help those in greatest need. We want people to behave responsibly and not do anything that causes their own homelessness. So when it comes to dealing with issues of causation, and actually I think it can be quite complicated and it can be quite complex, but when there's more than one factor at work, what a local authority has to do is to consider those factors that might be at play, and essentially arrive at the choice of one of those factors over another. And that's, my lord and my lady, is back to the case of Watchman at paragraph 18, the end of that one, so it's in tab 2.
Did you say paragraph 18?
That's right, the end of paragraph 18. It's all paragraph 18, but it essentially makes the point that when there might be more than one factor at play, what you're looking at is to find a substantial cause. And if there's more than one factor, all you need is one causative factor. All you need is that one of the possible causative factors is responsible for homelessness. That's the case of O'Connor, which we haven't included it, but I don't think that's going to be an issue. I have referred to it to my skeleton, but you just, as long as one of those factors is cause of homelessness. So ultimately, I say that comes down to a question of judgment for the local authority. And why do I say that? Well, I say that because the Act is framed in terms of a local authority being satisfied as to what, if any, duty is owed. I also say I'm supported in that proposition in the case of Cifci, which my learned friend relies on, and the comments by Lord Justice Lewison at paragraph. So Cifci is at tab 4. And it's the judgment of Lord Justice Lewisham. It's paragraph 7, but it's really the last paragraph, so it's about two-thirds of the way down. We start halfway up. These cases show that where there are potential multiple causes for a person's homelessness, the decision maker must make a carefully evaluate the facts in order to see whether the applicant's homelessness is shown to have been the likely consequence of his deliberate act or omission. And then further down, the ultimate question, and I say this is how intentionality cases should be approached. The ultimate question is, what is the real or effective cause of the homelessness? That question should be asked in a practical common sense way. So that, I say, is how questions of intentionality should be addressed. It's a fact-sensitive exercise. It's for the local authority to determine, but it's also a common sense exercise. So very briefly, sort of the key facts. I don't want to spend long on them because I know the court's already looked at them. But Church Road had been secured for the applicant through sort of main section 193 duty.
If you're going to be a few moments on the facts, shall we leave it there and come back at 2?
People just broadly leaving stuff here. Usher, is the court going to be locked at lunchtime?
You can always tell if it's off or on from the
Oh,
screen.
yeah.
Not boring or
I enjoyed it.
Yeah.
It did drag a bit, but it was good.
So yeah, so the appellant always goes first. They always sit on the right.
Mm-hmm.
Sometimes they will ask you that because they're not too sure where to sit. So appellant's always on the right. Then the reply will go back here, and then once she's done, it will go back to
Okay.
to respond to anything that she might say.
Okay. How long does she have to speak? Can she just decide?
There's not necessarily a time, but it's kind of like a common agreed thing that she won't take longer than he's taken.
Mm.
So they'll try and match it, but if she gets through her stuff quicker, then